Hi everybody, Dr. Stringer back from my office to talk to you this week about pretrial proceedings. This week is the first week after your midterm exam, so I am probably working on grading your discussion questions from that right now. And I usually like to tell people, you might have gotten a lower score on the exam than you actually thought you should have when it initially graded it. And please know that that's because I have not graded your short answer or your discussion questions yet. So the points that you have on there are only from those multiple choice questions that were automatically graded when you submit it. And so you'll get your additional points, as I grade those this week. So I like to tell people that. Of course, you guys are probably, not reading or listening to this until the week after I've already gotten that all done. But I assume some of you might actually listen to it early on in the week. So, nonetheless, we're talking about Module 9, which is on pretrial proceedings. So from this part of the semester on, we're going to be moving from kind of talking about the courtroom actors and the people that are there, kind of the courtroom work group, and we're going to talk more about the procedures and the way that things actually work throughout the pretrial, the trial, and even the post-trial sentencing phase within the courts. So getting a little bit more into depth with the courts and how they act and perform in order to achieve justice, if you will. So for those of you that don't know, the formal criminal justice process is, police will usually have this initial contact with a person that may or may not lead to them being arrested and things. And maybe even being detained while they're conducting their investigation, which is part 2. And then, they may or may not make an arrest. Those of you that have taken my policing class have probably heard me go on and on about different types of investigations and arrest procedures and things like that. But this is a courts class, so we're going to talk about more of those sorts of things. Then, if they do arrest the person, they'll, take them into custody, search them for weapons, interrogate them if they choose, all these sorts of things. And so that's kind of the end of where the police kind of leave off, is once they take them into custody. Then the courts and the prosecutors kind of take over. Now the police officers will probably come back to court if they were a witness or something like that to the crime to testify, but other than that, they're mainly done at this point. So then the prosecutor will decide whether there is enough evidence to charge the person with the crime that they've been arrested for. The prosecutor may decide that they want to null pros the case, in which case they've decided they don't want to prosecute the case, and you'll get to go free. Now the thing with that is the prosecutor is free to change his mind about that. So he could null pros the case today and then indict you again a month or year or years later. So don't think that you're necessarily going free. So then what will happen is a lot of times there's what's known as a preliminary hearing or a grand jury hearing. And this is where they determine if there's enough probable cause to hold a trial. There is an old saying that the grand jury will indict a ham sandwich, because pretty much everybody that goes before the grand jury gets indicted. It's almost like a rubber stamp on the process to say, hey, yes, you can charge them, and you can proceed on to trial. Then, if you get indicted, there will be what is known as an arraignment, where the defendant will go before the court. He probably, if he's got his own attorney will be there with him at this point. And then you usually will be asked to enter a plea of not guilty, guilty, nolo contendere, which means no contest, or something like that. And if you don't have an attorney, this is a time when they would read you your rights as well and tell you that you do have a right to have an attorney. If you can't afford one, then they'll check you out and evaluate your finances and things to see if you qualify for having an attorney. And if you do qualify, then they will appoint you either a public defender or a court-appointed attorney, as we've kind of talked about in the past when we talked about defense attorneys. Oftentimes at this point, there may be decisions made about bail as well. So if you're being held because you've been arrested, your attorney might decide to bring up the issue of bail at this point if you have not been given a bond or been issued bail by the magistrate when you're arrested. So, you might be released on bail. There's ROR, which is released on a reconnaissance, or you might be detained in the jail. If you murdered somebody, chances are you're going to be in the jail. You're going to have a really, really high bail bond when you get out, and a lot of jurisdictions now, they're holding people without bond for their third DUI. So that's another one too. And so you can actually, and if you don't bring up the issue of bail, you can actually request bail or bond hearings as well, which is a separate proceeding that can actually occur after or before arraignment. If you get arrested, maybe you've hired a lawyer and they requested a bond hearing to see if you can get bail and get out of jail. It's certainly beneficial when you go to trial to not be wearing an orange jumpsuit. And of course, if you're going to have your own attorney, it's certainly helpful for you to be out on bail and continue to work and make money to pay for that expensive attorney. So holding people is one of those ways that they help to negotiate as well, because people who are held in the jail and refuse a bond are more likely to plea bargain things because they know that they will be able to go ahead and start serving their sentence or possibly get out. But if you're being held in the jail, then this time, trials can take years, and you'll be in the jail that entire time, which can be quite rough, especially, you're not having any income at the time because you're in jail, but yet you have to pay for your lawyer and things like that, which can be challenging. And so those are one of the things that can lead to plea bargains. Interestingly, if you're sentenced to prison, then none of that time in those states that you spent in jail will count towards your sentence because you've been sentenced to prison and not jail. But most of the time, I've found that in most states, if you're sentenced to jail, then any time that you spent in the jail while you're awaiting trial would count towards your sentence. So you might even get time served and get out immediately. Then there's the issue of plea bargaining, which we've already talked about. This will probably happen around this time. Your lawyer will start talking to the prosecutor and seeing if maybe we can reach a plea in exchange for a reduced sentence, more lenient sentence, or something like that. Now, if the plea bargains fail and maybe the prosecution doesn't want to give you a deal, maybe you don't like the deal they offer you or something like that, then these things go to trial. And this is where the judge or the jury hears the case and decides on the defendant's guilt. And we'll talk more about the trial process after we get past this chapter, because this chapter we're just kind of talking about the pretrial process. And then after trial would come sentencing and disposition, which is where they sentence you to, the death penalty or prison or jail or community service or whatever you might get. We'll talk more about that as well. And then the final process that we'll talk about would be your appeals processes. So after you've been tried and convicted and sentenced, if you decided you wanted to appeal, then you could file appeals, which are kind of your post-trial and post-adjudication issues. So, and then of course you'd have correctional treatment and release and post-release, and this is kind of getting out of the court side of the criminal justice process and into more of the correction side of it. So if you remember, we started with kind of the police, and then we moved into the courts and the pretrial and trial and sentencing phase, and then this is kind of the back end where you're either in prison or jail, and then you're getting released, and then maybe you have post-release conditions of community corrections or parole and things like that. So I don't know if you guys have seen this in maybe your 1101 class, things like that, but this is just an illustration of the criminal justice funnel. And if you look at the very top there's 1,000, serious crimes. Well, about 500 of them get reported on, this is just an example, of course, it's going to vary across different types of crimes, and then, 500 of them go unreported, and then of those 500 crimes that get reported to police, only 100 of them have arrests made, and then another 400 go unsolved. And then if you see after the arrest is made, it goes down where the juveniles go to juvenile court, and then they might either be dismissed or put on probation, or they'll be incarcerated. And then the adults would go to be considered for prosecution. And that's about 65 of those 100 cases. Of those 65, about 25 of those cases will be dropped or null prossed by the prosecutor. The prosecution will decide that they don't have enough evidence to prosecute it. Another 40 will be accepted for prosecution, but of those, 10 of them are expected to jump bail or abscond from supervision, as it's known in the field. And of those 40, another 30 of them might go to trial. Of those 31 will be acquitted, and 27 will plead guilty. 2 will plead not guilty. And then, you have 29 that are sentenced, 20 go to incarceration, and 9 go to probation. So you see, out of the total 1,000 crimes that are committed, only 5 juveniles and 20 adults are actually incarcerated. So this is just another example using Alaska State Police reports of sexual violence. And so you see 1,379 cases, and then it just funnels down to where you end up, and this doesn't even talk about the sentencing phase, but you end up with 54 acquittals and 217 convictions, where it's kind of whittles down. Because this is kind of, you'll probably hear other professors talking about the funnel of criminal justice, how it goes from this very large amount of cases of crimes that are committed all the way down to this very small amount that actually go to prison or go to trial. And so the charging decision, the prosecutor in this sense is kind of meant to mean, or to be the gateway to justice. Some actually consider the police to be kind of the gatekeepers of the criminal justice system, because they decide who actually gets arrested, but the prosecutors get to decide who gets to go to trial. And so they may decide, that they're not convinced of the guilt of the person. They may be concerned about the possibility of the conviction. There might be some other policies that may just lead them to decide not to go to trial with this case. Maybe the victim is non-cooperative and doesn't want to testify, something like that. And then there's some other legally relevant factors as well, such as the seriousness of the offense, the strength of the evidence, the culpability of the offender, how guilty is he or she. Legally irrelevant factors like the behavior and motivations of the suspect and victims actually go into it as well. The victim characteristics, especially credibility, is going to be a big one. If you've got a victim that's not a very credible witness, it's going to be hard to prove the jury or convince the jury that they're not lying. So defense attorneys are notorious for trying to undermine the credibility of witnesses, as they should. And so there is an issue. Generally, there will be an indictment by the grand jury. There is this exception in some states where you can be charged by an information, and even states that allow it or very rarely ever see it occur. And that's probably because the grand jury will indict a ham sandwich, like I said. But this is pretty much where the prosecutor prepares a document and he signs it, which informs the defendant of what he's being charged with and the facts and elements and all these other stuff. And this is kind of a substitute for the grand jury indictment. So the grand jury has been required under the Fifth Amendment for federal cases. But they have not incorporated that Fifth Amendment right to apply to the states like they have some other rights. And I could get into this whole constitutional law issue about selective incorporation and how they've incorporated some of our rights from the Bill of Rights to apply to the states but not others. But then again, this is not a constitutional law class. We won't go there. But just know that indictment, you are required to be indicted by a grand jury in a federal case, but the states can choose to use the information if they so choose. And so if the indictment is handed down, then you will go to trial. This is required for felonies and capital cases only. You usually, I've never heard of a case, or even a state where you would have to be indicted or would even go to the grand jury for a misdemeanor. Of course, these things do vary somewhat across states, so you'll see different varieties of how this occurs and things like that. One thing to think about too is you don't have a right to be at the grand jury indictment. Usually this is just the prosecutor talking to the grand jury, but your defense attorney can sometimes be there, and so they'll sometimes go to try to get a peek at what evidence the prosecutor has. And so prosecutors will be very tricky with this and won't present all of their evidence to the grand jury for that reason, and then they'll just give them just enough evidence that they know would be enough for them to get them to indict them. So there is what is known after the indictment is what is known as initial appearance. This is usually within a few hours or a few days. If you're being detained, you'll advise the suspect why he or she is being detained. Well, you've been charged with murder and you've been denied bail. So then the judge would read the charges and explain penalties and your rights to a lawyer and these sorts of things. And then misdemeanors, you usually would enter a plea at this time. In felony cases, you'd set the date for the next hearing. So at this point, you would probably be seeing whether the person needed to have an attorney represent them at the next hearing and things like that. In misdemeanor cases, you would usually have your initial appearance, your trial, and everything all in one. Of course, that varies across states. I know back where I'm from in Virginia, if you get a speeding ticket and you go to court for it, you go to court on that day, and the judge will ask you if you plead guilty or what your plea is. They'll read you your rights, and then if you plead not guilty, then the trial will be right then. But here in Georgia, you have an actual initial appearance where they talk to you, see whether you want to go to trial, what you want to plead, all these other things, see if you need a lawyer, and then they schedule it for trial after that. So these things can vary a little bit across states. So they're all their own little court system, so to speak. And then there'll be some bail decisions made, like I said, or there might be a separate bail hearing. Usually your defense attorney will try to, get bail at the initial appearance, but, sometimes there might be time or it might not be time. The judge might not want to hear it. There could be different issues, and you might set another trial to be heard on bail. The prosecution might move for a separate bail hearing, especially in the event that maybe they wanted to call the victim or a witness or something like that to be there. So one thing to think about too is the rules of evidence do not apply to bail hearings. Hearsay, all of these things, they don't apply. So a police officer or a prosecutor can say pretty much whatever they want at a bail hearing. And so these things are not the same as trial, which determines your guilt. And so, the decision as to whether you get bail will be based on public safety as well as your risk of not showing up for the next court appearance. If you've had a previous no-show for court, where capias has been issued for your arrest, then the odds of you getting bail are much lower because they want to make sure that you're going to be there for court next time. And the easiest way to do that is to house you in the jail and make the deputy walk you over. It's important to remember, too, that the Eighth Amendment guarantees that bail cannot be excessive. And I think I've talked about this a little bit in class already, that you have a constitutional right against excessive bail, but you don't have a constitutional right to bail. So they can't give you $1 million bond for driving on a suspended license, but they can just deny you bail altogether. And so I think that's what part of the reason why they're giving this no bail for people with their third DUI, because the third DUI is generally DUI is generally a misdemeanor, and so the third one is usually a felony, but it's still there's been no victim, assuming you haven't hurt anybody, and if you have, you're not going to be charged with DUI, you're going to be charged with vehicular manslaughter. But that's one of the ways I think that they get away with doing that, is they're not giving you $1 million bond for your third DUI, which people might be able to argue is excessive, but they're just denying you bail, period, which you would not have any constitutional argument to be made there. And so many will use bondsmen to post bail, and this involves something called surety as well. And so in the event that you don't show up for court, then the bondsman will have to pay. Suppose you had a $100,000 bond. Well, if you have a $100,000 bond, usually the rate is 10%. You have to give the bail bondsman. And so nobody really has $100,000 sitting in the bank usually, and you'll have to pay 10% of that to the bail bondsman to bond you out. So that's still $10,000. And then you forfeit that. That's gone to the bail bondsman. But what happens is if you don't show up, then the bail bondsman will be held liable for that entire $100,000. And that's why you see Dog the Bounty Hunter and other people going out and finding these people when they don't show up for court, because the bail bondsman doesn't want to have to pay the $100,000. And this is just a $100,000 bond. Imagine if you had murder or something more serious, then there would be an even more amount of money, which is going to motivate Dog the Bounty Hunter to come and find you even more. So one of the things too that you'll probably hear about is when you go to bond someone out of jail, a lot of bondsmen won't bond somebody out without someone coming to sign for them and co-sign the bond. And the reason they do this, I've known several bail bondsmen, they do this because you might be okay with giving up that $10,000 as long as it gets you out of jail and then you can go to Mexico or whatever. But if you have your mom or dad or whoever co-sign that bond, then what's going to happen is if you decide to abscond and go to Mexico, the bondsman's going to come and they're going to call mom and dad and they're going to say, well, you co-signed for this bond, so now you're liable for that $100,000. And then I'm told that after that happens, those people that co-signed that bond become the very best of bounty hunters that they have, because they're happy to tell you or tell the bondsman where you are so that they don't have to pay $100,000. So that's the whole reason behind all of that, in case if any of you have been curious. So, at your arraignment, this will happen after bond, after all of your other things have gone on there. You'll usually be formally notified of the charges. You can waive reading because they're really just going to read you. You have been charged with murder in the first degree under section blah, 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 blah. So, some people have it read to them, others just waive it. Usually if you have an attorney, in the interest of time, they'll do it. I think the judges probably get a little bit irritated if you make them read it, especially if you have a lawyer, because it's more work that they have to do and it's taking time away from the court. Now at this point, the defendant will be asked to enter a plea. You can plead guilty, which means you did it, and you concede to that, in which case there will be no trial. You'll just go on to sentencing. The judge will usually read you a few things, because what happens when you plead guilty is you're waiving a lot of your rights. You're waiving your right to a trial by jury, you're waiving a right to confront any witnesses, and several other things to represented by counsel, and things like that when you plead guilty, because you're essentially saying you don't want to have a trial. And so then you waive all of those rights that go along with having a trial. And then you can also enter a not guilty plea. Now, a not guilty plea means I plead not guilty, exactly that, and you say that you did not, commit the offense that they've charged you with, in which case there'll be a full trial, and then they'll determine whether you've actually legally done it, whether there's sufficient evidence to believe that you've done it or not. You can also plead no contest or nolo contendere, as I've said before, which is similar to a guilty plea, but not quite as much. People do this because they don't want they don't want it to be used against them in a civil trial. So if you plead guilty to, say, vehicular manslaughter or something like that, maybe you're a drunk driver and you killed somebody, then that guilty plea can be used against you should the family of the person you killed decide to sue you for wrongful death or something like that. Now, if you plead no contest, what you're essentially saying is that you are saying that you don't admit guilt. You're not admitting guilt in this case, but what you are admitting to is that the prosecution has a case that is strong enough to convict you, and so you're not going to try to argue your case, but you're also not admitting any guilt. Now, in these cases, it goes right on to to sentencing in the same way that it would have had you have admitted guilt or pled guilty. It's just that your admission of guilt, there will be no admission of guilt to be used in collateral proceedings such as your civil suits and things like that. You can also stand mute and not enter any kind of plea. If you do this, then most likely what's going to happen is they're going to send you off for some sort of psychiatric evaluation to see if you are competent to stand trial and competent enough mentally to be able to help in your own defense and things like that. This very rarely ever happens, and is probably very irritating when it does happen. Personally, I've never seen it happen, at least not in court. I've seen people do this when it comes to police, but not necessarily in court. And then your Alford plea is the same thing as a no contest plea. It's just called an Alford plea sometimes. But in some states you cannot actually do that. They won't allow that. So that's another interesting thing to think about. Then there is what is known as discovery. Discovery is where the prosecution and defense learn of each other's evidence that they will use. Different states have different requirements on discovery, and they vary also according to whether you're charged with a misdemeanor or a felony. And there's a big case known as Brady versus Maryland, which says that any time the prosecution is in the possession or is aware of what is known as exculpatory evidence being evidence that proves that the defendant is innocent, then they have to turn that over to the defense. And if they don't do that, then you can have the case thrown out and things like that. Anyway. And that's what that constitutional right to any evidence that shows the defendant is innocent. Brady versus Maryland and exculpatory evidence. Also you should notify the prosecution of any affirmative defenses at this time. So maybe an alibi defense, self-defense, or an insanity plea. You can also plead. In some states, your plea would actually be different. If you plead not guilty by reason of insanity, that's a separate plea, but that varies across states as well. Then you would file any kind of pretrial motions. Usually there's a motion for discovery. So you would move that the evidence be disclosed to you. Your lawyer might decide to file any other motion, such as a motion for dismissal of charges, in which case there'll be a hearing to see if there is probable cause to go forward with the trial. And the judge will rule on this and probably deny that type of motion. You could have a motion for a change of venue. If you can prove that maybe the media has tainted the jury pool really bad in the area where the trial is to be held, then you can move that there be a change of venue to a different place. There hasn't been as much media attention. You've probably heard of this happen in the media as far as big profile cases and things like that. You can have a motion to suppress evidence, which means maybe there was some sort of evidence that should be excluded. Maybe they conducted an interrogation or a search or something like that, which violated your rights, and so then that evidence should be excluded from that. There's a whole bunch of other reasons, which I won't go into all the details, with regard to rules of evidence, and they vary very much across states. but some evidence will be introduced and others will not, and so obviously your defense attorney wants to try to suppress as much of the evidence that the prosecution wants to get in as possible, and so then the judge will have to rule on that. There's motions for severance of defendants. A lot of times if people have committed a trial or committed a crime as a group, then they all be tried all together, which can not really be that beneficial for people who were not the primary actor in the crime. Maybe if you're like the getaway driver in a bank robbery, you probably don't want to be tried at the same time as the people that went and shot and killed the people while they were robbing the bank, but that's probably what's going to happen. Of course, your defense attorney might try to make a motion to sever you from this trial, but those very rarely are ever granted. And then there might be a motion to determine your mental competency, and this would usually go along with some sort of plea of not guilty by reason of insanity or something like that. And so that is all that I had to talk about for today. Please make sure that you don't forget to do your discussion boards and quizzes, and I look forward to talking to you next week.